Go ahead and get started, Dr. Slay.
Sounds good. All right. Well, we have the call to order and a declaration of quorum. Third item on the agenda is just introduction of new commissioners. There's 2 new commissioners since we last met in December. Chief Doug DeLever, who is not on the call today. Hopefully will be, he has some health issues, so hopefully he'll be able to join us at our next meeting. And I'm also pleased to introduce Althea Miller, who is our new victim advocacy representative. She replaced Molly Knipe, and she just got appointed by the governor just a few weeks ago, and had a good opportunity to speak with her in advance of today's meeting and get her caught up as much as possible. So thank you, Althea, for accepting the appointment to the commission, and we welcome you as our newest member.
Thank you for having me.
Welcome.
Okay, and I do see Delegate Klippinger, so hello, Delegate. All right, so Judge Wilson, do you want to proceed with agenda item 4?
I'll do that. Members Commission and any folks who may be tuning in, item 4 on the agenda is something that David suggested, and I certainly agree with. But because of the times that we're in right now and some of the difficulties we're having as a nation, specifically around the criminal justice system and law enforcement generally, we thought it would be a good opportunity for us as a commission to have a discussion. It will be an open forum discussion just about remembering the mission of this commission, that it is beyond just trying to balance out sentencing across the state and the different jurisdictions, but also identifying those other factors that have come into play, that whether it's a cause of or a result of sentencing policies, that race in particular is an identified factor that we need to consider as commission at all times to ensure that all persons of Maryland are treated fairly in the courts, in law enforcement, and certainly when it comes to disposition of criminal cases. Because of that, we thought that this item 4 would be appropriate this time, and to allow any commissioner who has thoughts on or has questions about or in any way wishes to discuss this matter, that we do this in this open forum to make sure that the people of Maryland who do watch us and do understand the purpose of this commission have an opportunity to see that we are not some distant group from the public, but in fact, we do care for the public. We care for the trust that the public may have in this commission as well as in the criminal justice system, and that the best way to do that is to have an open and transparent discussion of where we are as a nation and a community. So at this point, I would certainly entertain anyone who wishes to open this part of the discussion with their thoughts or, again, comments on this commission and what its role is and how we can also help to try and heal the area and the community.
Judge Dolores Kelly.
Yes, Senator.
One thing that I find really interesting right now is the extent to which we are going back centuries in the past, looking at the role again that people that we sometimes saw as scoundrels from the beginning and in other cases as heroes, and to see what people's whole lives are about. Most of us are mixed, and on some day our parents would have said we deserved a spanking. But I think that this commission, and though I'm not sure how, maybe except when we do our December meeting, we invite the public to come and tell us from their perspective what they're dealing with and their impressions of the criminal justice system and what they think should be changed. There are probably going to be a lot of cases coming up about statutes and historic artifacts. It was just instructive for me to both think about Christopher Columbus' so-called discovering America, and then to hear that from the perspective of indigenous people, not only did he bring slaves also to America, but that from the perspective of indigenous people in this land, that people were disemboweled apparently by him. So it lets us know that we are all imperfect beings, and that we've got to re-examine history anew. I think in many cases, we probably saw, for people who managed to have great name recognition, the good and maybe not the bad and the ugly. And we've got to figure so that we really can understand history in totality, how to recognize both aspects, sometimes in the same human being, and that in cases where we may not want to venerate a particular historic figure by saying we'd create a new statute in their honor, or necessarily preserve an old one in the setting that it has been in, because people assume you're there because you really were great and that greatness is all you are. But as some probably need to be in archival sites where people go to study and to learn and to become experts to help the rest of us to understand. I won't say more, but it's really complicated. And it's something I think we're going to have to wrestle with. You're probably going to have folks before you in the courts soon, in some cases, because of their concern about their new understanding of history. And I think that's an aspect that in the past maybe wasn't before us.
Thank you, Senator. Would anyone else like to join in the discussion? Mr. Fincy?
Thank you, Judge. I don't have Senator Kelly's larger vision of things. I'm sort of on the role of the commission when I have observed what's been going on in the broader society. And it frustrates me at times, and I'm just going to come out and say it, that sometimes our mission as a sentencing commission can serve to perpetuate longer term issues of over-incarceration, because that's sort of inherent in our mission. If sentences are supposed to be consistent throughout the state and they're continuing to be a certain length, that issue of over-incarceration perpetuates through our guidelines sometimes. And I have at times tried to call that out when I could. I think that our current renewed effort to review the guidelines to see how the Justice Act, Reinvestment Act has affected guidelines is going to be very important for us to look at very carefully so that we aren't perpetuating this over-incarceration politics that are now going on in the broader society.
Thank you. Would anyone else like to join in?
This is Bill Davis with the Public Defender's Office.
Yes, Mr. Davis.
I agree with Mr. Fincy, and I get frustrated as well with the situation. And I take a look at, and I'll just give an example. Sometimes the guidelines are quite broad in their ability for a court to use their discretion. When you have guidelines like from 12 to 20 years, that's a pretty big gap. And I don't know what to do about that. And I understand some of the reasons for the gap, but I just wonder how that is used to perpetuate, as Mr. Fincy says, the over-incarceration of individuals and perhaps individuals of color. So that's a concern that I've had and I've always had. What makes the difference between 12 years and 20 years? Is it the jurisdiction? Is it the individual? If two people are really in the same boat, why is one getting 12 and the other getting 20? So I just think that's something else that we have to look at and decipher whether or not it's being utilized appropriately.
Okay. Thank you. Dr. Johnson?
Yeah, thank you, Judge. I just wanted to add that Mass incarceration is a broad societal problem, as Mr. Finzi pointed out, but it's beyond that because it disproportionately impacts some groups. And if you look at demographics in our country, African Americans constitute between 12 and 13% of the population, but they're the modal category in our prison system, right? And one of the, I was looking back at the guidelines manual this afternoon, and one of the express directions that it gives us, and I'm going to quote this, is to increase equity in sentencing by reducing unwarranted disparity, including any racial disparity. So it's actually part of our mission as a commission. It goes beyond worrying about overuse of incarceration. I don't disagree with anything that's been said, but we do have a responsibility as a commission, I think, to be cognizant about the potential racial impacts of any policy changes, policy decisions that we make. So I think this is just a good opportunity to remind ourselves that that is part of our mission as a sentencing commission, to be concerned with ensuring racial equity, and to think, broadly about the kinds of policy decisions that we make and how they might have unintended consequences as we're trying to do our best to be fair and equitable for people of all backgrounds. So that's it. Thank you.
Thank you, Doctor. I think that you're absolutely correct. Before I get to you, Judge Avery, I see that Chief DeLever has joined us. Chief, I just want to let you know that first off, your mute button is still on. And secondly, that Dr. Soleil did give a brief hello to you earlier introduction, and we certainly welcome you to this commission. Is there anything you'd like to say before I turn it over to Judge Avery?
No, this is my first time on, and I really appreciate it. I've been going back and forth to doctors, so I'm privileged to be on this committee.
Well, we're happy to have welcome, and thank you for joining us.
Thank you.
Judge Avery.
Thank you so much, and welcome, Chief DeLever, and also, is it Althea or Alethea?
It's Alethea.
Alethea, okay. Thank you so much, and welcome.
Thank you.
When I saw this item on the agenda, I felt really uplifted for a number of reasons. Number one, it's important for us to talk about these issues. And number two, the identifying and reducing or eliminating racial disparity has been the mission of this commission by statute, by express statute, and even before that. The whole purpose of the sentencing guidelines, the mere existence of the guidelines has as its underlying purpose to identify and remediate the problem of racial disparity, which has always been a problem, and it continues to be a problem. And it is one of the foundational blocks. When I talk about racial disparity in sentencing, it is one of the building blocks of what is commonly referred to as structural or systemic racism. And so as a judge, as a member of the Maryland judiciary, I think it's important to recognize that and to start a conversation about it. But the exciting thing is that this sentencing commission has been talking about it for 30 years. And that is really exciting. And I want to say thank you to Senator Kelly and the other colleagues that I've known for so many years on this commission. We've always grappled with that question. And one of the things that I've learned is that addressing structural racism really is data. I want to say data is really important when you are trying to dismantle structural racism or remediate it. And what I have found over the many years with this commission is that all of our data analysis, when we look at it, and I'm thinking most recently of the juvenile scoring process that we went through, the question always was, how does this practice or that practice result in a disproportionate impact on people of color? And so that's what we're here for. We've always been here for that conversation. And I love that now we can just make it a centerpiece and talk about it openly and explore and learn new ways that we can address this problem of structural racism, and specifically as it relates to this building block of sentencing policy. So I think that we have a lot to be proud of on this commission, and we have some really good practices to build on. I would like to see us have an express conversation and brainstorming session on how we push that even further now. The time really is now. It's such an important time to talk about these issues. And so I guess, you know, this isn't a formal motion or anything, but I would like for us to consider having a special meeting that would be related to how this commission is carrying out its mission of identifying and remediating racial impact. And the reason why I say that I think we should have a special meeting is because it's important for us as a very diverse group. I mean, by definition and by statute, we're very diverse. We come from different perspectives. We have defense and prosecutors and judges and other justice partners and corrections and police. I think that in a diverse group that we need to learn how to talk about race. We need to learn how to talk about disproportionate impact on people of color in a way that allows all voices to be heard. And I will tell you, it's been my experience doing diversity and racial justice work since way before I was a judge, that there are a lot of reasons why some people's voices aren't heard. And I don't need to go into all of them right now, but there are facilitators who are excellent and can come in and give us some tips and help us find a protocol for talking about this topic, I think, in a way that will be very productive. So, and then from there, I think that, you know, we're experts. We can really work together to come up with some great ideas on how to address this issue of disproportionate racial impact in sentencing policy. Thank you.
Thank you, Judge Avery. And we do have our next meeting scheduled September 15th. I would say certainly between now and then, perhaps we can put your thoughts into practice and actually move forward on that. I think that'd be good. Would anyone else like to comment at this time, or save comments for a later date, whether it's a special meeting or the next meeting, as we move forward on this issue?
If I may, Your Honor.
Absolutely, Rob.
Robert Green, and would like to echo Judge Avery's sentiments around data and information. The dashboarding of data. We have a great deal of information, thanks to Dr. Soleil and others, but the ability to take that information and put it in a context, a dashboard, something that is before us all the time, the ability to look at a piece of information at a dashboard, and within 30 to 60 seconds, it tells you where you're at with an issue, what your challenges are, and how you're maneuvering through that. And the dashboarding of data, I think, is critical. We have 30 years worth. We have new data from Dr. Soleil, but that really is a point that needs to be in front of us. It needs to be something that we can regularly look at. And again, we often talk about data, but it can get very complex. But when you break it down to the metrics that you want to achieve and that which you want to follow, the dashboarding of that and having that available as a supplement to a website, or the impact of that, and really, quite frankly, from the correctional perspective, what do we want to accomplish? What do we want to within my system, the opportunity for change, the opportunity for real focus on helping people is where we want to be with the reality of the number of our population that are returning back to our communities, and how we do so is all a part of that front end journey from sentencing to going home. Thank you for that opportunity, Your Honor.
Thank you very much.
Can I chime in as well, Senator Cassidy? So I just
Yes,
echoing Mr. Green's sentiments, but and perhaps David could enlighten us. I'd be very interested in, maybe you provided it and we get a lot of information, but specifically what data we have that shows that people who are scoring the same are being sentenced differently. I assume that's what we're saying based upon their race or gender or whatever. Is that something that we have do we have that data now? Have we looked at that? I know we looked at that in the juvenile context. We've gone through that, but for the, we're talking specifically the adult population, I think is what we're really talking here. Do we have that already? Do we have, has it been put in the format of a report, or as Mr. Green was saying, a dashboard?
So Senator Castley, we have the data. It hasn't been presented in the way that you're requesting it in a recent manner. The commission many years ago did a systematic study of the impact of race on sentencing when controlling for all the relevant factors, including, prior record and the offense of conviction, et cetera. That study is now 20 years, well, close to 20 years old. And the commission certainly has the data to look at that information. As you noted, we did it in some respect in a much more micro scale version of it when we looked at the juvenile score. And that was how adults, how we were calculating one's prior record, including specifically whether they had any juvenile record. And, we really, those that were on the commission at the time, remember, we really poured through the data in that respect to kind of look at that with really the primary outcome of addressing, eliminating the disparity that was identified in that African Americans were more likely to have a juvenile record indicated via commitment, and there was some disparity that was being introduced in that respect. So that was something that we, looking at the data, were able to figure out that if by using adjudications rather than commitments as the measure, we were able to eliminate the disparity in that particular measure. So that's something that was kind of a long-winded way of addressing your answer. We have that data, Senator Castley. We don't have it presented in the dashboard manner that Secretary Green spoke about. I think that there's certainly some utility to that, and that's something we would have to look into in terms of how we would be able to achieve that. We don't currently have the platform to be able to do that. We would have to look at that and see, maybe we could piggyback off some of the work that the Department of Corrections is doing in that manner. But we have the information, and the question is what type of analyses this commission might be looking for going forward.
And the dashboard, I mean, those are always nice to have, but obviously there's technical issues on that. So perhaps scaling that down to something a little more simple with any report that we could get at this point. And I mean, is that something that would take 20 people a year to put through, or is that something that, I mean, between the two extremes, you sit at your computer and it takes you 20 minutes to pull it up? Where are we in that wide?
Somewhere in the middle of what you described. Definitely not 20 minutes. It's something that we'd want to put, a fair amount of thought into. I think that's something that's doable, to certainly do a study on the impacts of race and sentencing while controlling for all the factors. We want to be very careful, obviously, in doing that analysis. There's some limitations to the data that the Sentencing Commission itself has, because we just have the information that is collected via the guidelines worksheet. That obviously doesn't have the information about the specifics about one's prior record. We just have an aggregate measure of the existence of their prior record. We don't know anything about the prosecutorial decision making that went into that ultimately led to their conviction charge, et cetera. But it is something that we could, if that's something the commission is interested in, Senator Castley, we could kind of develop a plan for what would be the best approach to do that. And I probably would reach out to Dr. Johnson and maybe a couple of his colleagues at the university and the Department of Criminology and Criminal Justice to ask for some guidance on the best approach for completing that study.
If I could butt in and just make one last quick comment. A couple of days ago in the Sun paper, there was an article featuring an African-American business owner who had a criminal record. He had earned, I think, $9 million last year. He had several employees and he applied for one of these business loans under the CARES Act. And he was not going to get it in the Small Business Administration because he had a criminal record from when he was a kid. He had done so well, that it was interesting. That's another end that it might not be exactly within our bailiwick, but sometimes when we look at people and we do look to see, well, what record do they have? In this case, if your record's bad, it really harms you. If you got a really good record and you're an outstanding individual and you're doing good, we have no way of accommodating that when we look at you as you go forward into the future.
Okay, thank you, Senator, and you're correct there. I mean, without getting into technicalities, I know there are ways that older offenses over time degrade and go out of way, but it is, all of that is a part of the new puzzle that we really need to look at. For all the great work that this commission's done in the past, obviously we know we have more to do. And I think this is a good new beginning to getting back into the business of, if need be, recreating the wheel, so to speak, so that it fits what we now understand. Thank you all for participating in this portion. And I think I would generally say that there is a consensus among all of us that we have work to do. And as Judge Avery indicated, it's time to focus on it perhaps a little more. And even if that requires a special meeting. So thank you all. And we'll look forward to more ideas and work for us to get done. With that, back to this meeting for today. The next portion is approval of minutes. We have a slew of minutes that we have been stacking up and haven't quite gotten to yet for approval. Just so you know, what we're going to do, instead of having a voice vote in favor of passing minutes, we're going to start at the opposite end as we get to each individual set of minutes and simply say if there's anyone who opposes adopting these, that they would say yes. Otherwise, we'll let the silent majority rule, since it's hard to judge who's saying what on a Zoom call. Right. So first, with the December 10, 2019 MSCCSP business meeting minutes, they have been forwarded. Does anyone have any corrections or alterations to them? All right, seeing none, I would accept a motion to accept them if there's a motion.
So moved.
Okay, Senator, second.
I'll second.
Mr. Fincy seconding. Okay, anyone opposed to accepting the December 10 business meeting minutes, say nay. All right, hearing none, they are approved. Next, the December 10 public comments hearing minutes, the second part of that evening's agenda. Again, are there any additions or corrections to those minutes as presented? All right, seeing none, is there a motion to approve?
So moved.
Okay, is that Secretary Green?
It is. So moved.
Okay, is there a second?
Second.
Thank you, Senator Kelly. Okay, anyone opposed to the adoption or acceptance of those minutes signify by saying nay. All right, seeing none, move forward to the January 29th, 2020 teleconference meetings, again, which should have been provided in the digital packet sent out. Are there any additions or corrections to that packet? All right, hearing none, Is there a motion to approve the January 29 teleconference meeting minutes?
So moved.
Seconded.
Okay, so Ms. Bicknell and Mr. Green, we have motion and second. Anyone opposed to the acceptance of the January 29 teleconference meetings signify by saying nay. Hearing none, they are passed. All right, finally, the February 2020 teleconference meeting minutes. Any additions or corrections to those? All right, hearing none, is there a motion to approve?
Moved.
Okay, Ms. Grenier, second.
Second.
Ms. Bicknell, thank you very much. Anyone opposed to the acceptance of those meeting minutes signify by saying nay. Okay, hearing none, they are approved. Thank you all very much for getting that business work done. Next item is item 6. This is a guidelines subcommittee report from Judge Avery. I'm sure there are a few things for us to talk about.
All right. Good evening, everyone. Again, I just want to say that the guidelines subcommittee did meet on June 18th, and it was Brian DiLeonardo, Rick Fincy, Senator Kelly, and Judge Wilson and myself on that call, as well as Dr. Soule and other staff members. We had a robust conversation, as we always do, and we reviewed all of the proposed classification of new offenses, as well as we had a conversation about our ABA plea policy. So I just want, with that, I'm going to turn it over to David because it was a rather long meeting. We covered a lot of ground, and David is a lot more efficient in how he describes that. So I'm sure you'll all be happy that David's going to take it from here.
All right, thank you, Judge Avery. I will try with that efficiency. It is long, but we will get through it. So I will begin with agenda item 6A, which is the proposed classification of new or revised offenses from the 2020 legislative session. And I'd like to start with just a little review about how the commission classifies new and revised offenses. And I'll provide a quick explanation of what was covered in the materials that were sent to you. We have several new commissioners to this process, so I kind of just want to go through how we do this. Each year, the commission will review any new and revised penalties that are adopted by the legislature and consider how those new or revised offenses will fit within the sentencing guideline system. And the task of classifying those new and revised offenses is designated at first to the guidelines subcommittee. In preparation for that task, the staff reviews all legislation from the session and identifies any offenses that create new penalties or alters existing criminal penalties. We then prepare a memorandum that will identify those, and we focus only on those that carry a maximum penalty of greater than 1 year or 1 year or greater of incarceration. We do that because by rule, the commission does not require classification of offenses that carry a maximum penalty of less than 1 year. Rather, those offenses are automatically assigned a seriousness category of 7, which is the least stringent seriousness category. So with that introduction complete, I'll refer you to the memorandum that was sent out that is labeled Proposed Classification of New or Revised Offenses for the 2020 session. That is a 13-page document that's divided into 3 sections. It's the first section is new offenses with a penalty of 1 year or more. The second section is altered offenses or existing offenses, with an altered maximum penalty. And the third is additional amended offenses that have no recommended action. And I'll kind of describe what those are at the end. For your reference, we also provided a supporting document that was labeled Combined File of Legislation with New and Revised Offenses for 2020. That is a PDF that combines all the legislation that is reviewed in the New or Revised Offenses memo. The bills appear in the order which they are listed in the proposed classification memo. Based on the established protocol, the subcommittee will make seriousness category recommendations by examining currently classified offenses or existing offenses that are comparable, and we call those comparables. When we look at offenses that are comparable on the following: the type of offense, whether they're a person, drug, or property offense, the statutory maximum, the misdemeanor felony classification, and when possible, the nature of the offense. For each new or amended offense, the memorandum provides identified comparables at the bottom of each page, or in some instances on the following page. Okay, so I will start by reviewing the one new offense that we identified for 2020. That's on page 1 of the memorandum. This is chapters 21 and 22 for House Bill 5, Senate Bill 161. This creates a new offense prohibiting a person from placing or inscribing an item or a symbol, including an actual or depicted noose or swastika, whether temporary or permanent, on any real or personal property, public or private, without the express permission of the owner, owner's agent, or lawful occupant of the property, with the intent to threaten or intimidate any person or group of persons. There are similar hate crime offenses that are listed as comparables on page 2. The recommendation that was made by the subcommittee is based primarily on the first comparable, which is also a misdemeanor with a 3-year maximum penalty. And based on this comparable, the guidelines subcommittee recommends classifying this as a person offense with a seriousness category of 5. Is there any discussion on this classification? Okay. How do we want to sorry, Judge Wilson, how do you want me to just ask if there's any discussion or opposition? Proceed
Well,
if there
I
is no
think,
opposition?
I think we'll need a motion, obviously, to approve that first, and then we can open if there's any further discussion or opposition. We'll do voting the same way we did for the minutes, if that's okay with everyone on the commission. First, is there a motion to approve the subcommittee's recommendation?
I so move.
Thank you, Senator. Mr. Fincy, you second?
Yes, I'll second. Thank you.
Okay, thank you very much. At this point, is there any further discussion on this point? All right, hearing none. Is there anyone in opposition to the subcommittee's recommendation, item 6A? If so, signify by saying nay. All right. None heard. The measure passes.
Great. Moving on to page 3, I will now review offenses with changes to the existing penalties. And we will continue with chapter 45, which is House Bill 81. This bill repeals the crime of sodomy. Accordingly, the subcommittee recommends removing this offense from the guidelines offense table. That is the recommendation.
Okay. All right. Again, is there a motion to approve the subcommittee's recommendation?
I move approval.
Thank you, Senator. Second?
I'll second that.
Thank you, Delegate Moon. Good to hear your voice. Okay, any discussion on this proposal?
Point of information.
Yes, go ahead.
David, is there a provision or something in the guidelines that instructs not to score an offense like that for criminal history purposes when it's removed?
Yes, we adopted a provision just to that extent a few years ago.
Okay. To the criminal history side of it, right? Yeah, okay.
Correct.
I remember.
Thank you for the clarification, Mr. Fincy and David. All right, then, same thing. If anyone opposes this recommendation, please signify by saying nay. No opposition heard. Measure passes.
Okay, thank you. Moving on to page 4, chapter 93. This is House Bill 171. The relevant portion of the bill that we're looking at here alters the penalty for interfering with, injuring, tampering with, or destroying a horse used for a certain purpose to prohibit a person from interfering with, injuring, tampering with, or destroying an equine used for a certain purpose or any other lawful activity. The bill changes the crime from a felony to a misdemeanor and alters the maximum penalty to include a fine not exceeding $1,000 or imprisonment not exceeding 1 year or both. So the penalty was decreased from a maximum of 3 years to 1 year. Based on that decrease and the reclassification to a misdemeanor and the given comparables that we provided, the subcommittee recommends decreasing the seriousness category from now 1 year misdemeanor to a seriousness category of 7.
Same format. Would anyone like to make a motion to approve that measure?
I so move.
Thank you, Senator. Is there a second? Mr. Fincy, thank you. Is there any discussion or questions on that matter? All right, hearing none. Again, if there's anyone in opposition to that measure, please signify by saying nay. None is heard. Measure passes.
Okay, moving on to page 5, chapters 128 and 129, House Bill 246, Senate Bill 231. This bill establishes a new penalty for a subsequent violation of sexual solicitation of a minor or law enforcement officer posing as a minor. The bill also expands the definition of sexual solicitation of a minor or law enforcement officer posing as a minor to include knowingly and with a certain intent soliciting the consent of a parent, guardian, or custodian of a minor, or a law enforcement officer posing as a parent, guardian, or custodian of a minor to engage in certain prohibited sexual acts with the minor. The comparables provide the seriousness category for a first violation of this offense, which carries a 10-year maximum penalty. We also listed similar sex offenses with 20-year maximums. Based on the comparables, the guidelines subcommittee recommends a seriousness category 3 for this subsequent violation. This is one of the offenses that probably could have been listed under the new, but we decided to list it under as an amended offense because it created a subsequent version of an already existing offense.
All right, thank you, David. Again, is there a motion to approve?
So moved.
Thank you, Ms. Bicknell. Is there a second? Mr. Green, thank you very much. Any discussion or question about this measure? All right, seeing none. Is anyone in opposition, again, opposition to this measure, signify by saying nay? None opposed. Measure passes.
Thank you. Moving on to page 6, chapters 385 and 386, House Bill 947, Senate Bill 169. This bill increases the penalty for practicing or attempting to practice dentistry without a license and alters the penalty of a violation of soliciting or advertising to the general public in any manner that the person alters, constructs, duplicates, repairs, or supplies a dental appliance without a dental license, and increase that penalty from a misdemeanor to a felony. Based on the provided comparables, the guidelines subcommittee recommends classifying a first violation of practicing or attempting to practice dentistry without a license as a person offense with seriousness category of 7. The subcommittee recommends classifying a subsequent violation of practicing or attempting to practice dentistry without a license as a person offense with a category of 6. And for the last one listed there, conducting unauthorized dental lab work or advertising a dental appliance without a dental license, the guidelines subcommittee recommends a classification as a property offense with a seriousness category of 7. The guidelines subcommittee debated the offense type classifications for these particular offenses. That is, whether they're classified particularly as property or person offenses. There was some question about whether conducting unauthorized dental lab work without a license should be classified as a person offense as it relates to something being added to an individual's biological system, which could potentially result in injury or even death. It was noted, the subcommittee did note that the guidelines difference, whether it's a person or property offense, in this case, it is negligible. However, if the offense were classified as a person offense, additional elements would be scored. And those are whether there was victim injury, weapon presence, or if the victim was especially vulnerable. I remember Judge Wilson, who participated in the subcommittee, he did ask if there was a corollary statute concerning medical devices in labs, whether it be a prosthetic or pacemaker. It was noted that practicing medicine without a license is an established offense, although it does not specifically speak to medical labs. If there is another similar offense, we didn't identify it, but it's probably one that's not punishable by 1 year or more, and therefore it wouldn't be on the guidelines offense table. So it wouldn't help to particularly inform our discussion. Ultimately, the subcommittee decided to recommend going forward with classification of the final offense, which was conducting unauthorized dental lab work as a property offense, as we thought that was most consistent with the other comparables. Finally, It was noted that if going forward, we think that there's an issue with that classification, obviously the commission can review it again at a future date. So I'll present those. That's really 3 offenses wrapped up in one, but those were the recommendations of the subcommittee.
Thank you, David. Is there a motion?
Move approval.
Thank you, Senator. Second. Mr. Fincy? Okay. Dr. Johnson, we'll get you next time. Thank you. Okay. Again, any discussion or question about this? Hearing none. Anyone opposed to this measure, please signify by saying nay. None opposed. Measure passes.
Moving on to page 7, this is chapter 613, Senate Bill 395. The relevant portion of the bill here expands the definition of various offenses related to the unauthorized practice of health and medical professions. The offenses identified on this page are not new offenses, rather they are existing offenses that were not previously classified. The 4 offenses are practicing respiratory care without a license, practicing radiation therapy, nuclear medicine technology, radiography, or radiology assistance without a license, practicing athletic training without a license, and finally practicing perfusion without a license. The staff identified these previously unclassified offenses while researching the previously discussed dental bill. And so that's how we identified these as needing classification, if you will. Based on the provided comparables, the subcommittee recommends classifying each of these 4 offenses as person offenses with a seriousness category of 7.
If I could butt in, I voted with you at the time, but just seeing what's happening in this pandemic, and if you were somebody who was testing positive for this virus, and somebody holds themselves out as a respiratory therapist, and they are not, they could really kill you. So I'm inclined to say it probably is more serious than I was thinking about at the time I considered it initially. But that's just my say.
Well, Senator, as you know, the legislature can always retake a measure the next session too, if need be. But as to the measure as presented at this time, is there a motion to approve it subject to further amendment by the legislature as it deems necessary? Any motion to approve?
Motion to approve.
Thank you. And Secretary Green, I saw your hand up for a second. All right, any further discussion or question? Hearing none, is there any opposition to this measure? If there is, please signify by saying nay. Hearing none, the measure passes.
Okay, for the remainder of the document, which is pages 8 through 13, there is no recommended action by the subcommittee. There's no action recommended for these particular amendments because there were no changes to the penalty structures for these particular offenses. I am happy to review any specific offenses that have no designated action, but I will defer to the commission to decide if any offenses require or any of the bills require specific review.
And does any member of the commission wish to inquire about any specific bill or the or specific provision or the provisions overall? Okay, thank you. Mr. Slay or Dr. Slay?
All right, well, that wraps up the agenda item 6A. So we'll move on to agenda item 6B. Again, more classification, so bear with me. This is the proposed classification for common law forgery, and I refer you to the memorandum with that same name. So this is an issue that was brought to our attention by an assistant state's attorney who contacted us at the staff to inquire how to calculate the guidelines for the offense of common law forgery. In this instance, the state's attorney's office had charged the defendant under common law for the forgery or counterfeiting of a welfare benefits application. Maryland's criminal law article provides for penalties for the creation or forgery of and use or uttering of certain counterfeit documents. In Maryland, forgery and uttering are also prohibited under common law. The Court of Appeals in Maryland has held that when a statute is enacted, common law still applies where the statute was not intended to cover the whole field, as is the case in forgery and uttering, or was not intended to repeal the common law. Common law forgery is used in Maryland to charge offenses that involve counterfeiting private or public documents of legal significance other than those that are listed in Criminal Law Article 8-601 and Criminal Law Article 8-605. For instance, a police report, a welfare benefits application, or other government document. Similarly, common law uttering is used in Maryland to charge offenses that involve the use of counterfeit documents that are not listed in Criminal Article 8-601. Both the creation of and use of a counterfeit document as provided in the criminal law article carry a statutory maximum incarceration penalty of 10 years. The maximum penalty for a common law offense is limited only by the constitutional prohibition on cruel and unusual punishment. In response to this issue, the subcommittee recommends classifying common law forgery and uttering and adding these offenses to the offense table as seriousness category 5 offenses, which is the same seriousness category classification for statutory forgery and uttering. You can see this outlined on page 2 of the memorandum. I present that as the recommendation of the subcommittee.
This is David Moon. Can I ask a point of information here?
Yes, sir.
Just for my education on this, because I've always been one to frown upon leaving common law sitting there when we can just codify things. What happens, because I'm looking at this max life when the codified equivalents are at the 10 years, just for my curiosity, does that mean to say if someone charges the common law forgery offense because the document type isn't specified or something like this, that they actually are facing life?
I mean, technically speaking, I guess yes, but as far as the practical, I don't think you're going to find that's ever happened. But the common law does not put limits on sentences as statutes do, and obviously that's one of the main purposes of this codification, is to bring certainty to both the elements as well as the penalty.
Interesting. It's an interesting thing. Okay, thank you. Carry on.
Yeah, one thing, Delegate, is every sentence is, of course, also somewhat controlled by the Eighth Amendment, the cruel and unusual punishments, which sometimes have stepped in certain common law offenses to put not legislated caps, but judiciary and created caps. So, but generally, you're correct.
Got it.
All right, any other points of information? Yes, Dr. Johnson.
I mean, this is for my own edification. I just have a follow-up question, but the guidelines don't classify most common law offenses, right?
I think they are included in there.
Yeah, they are. So we have gone around, Ryan. We have classified the more commonly charged common law offenses. Okay. And the subcommittee had a really good debate about this. In that the staff had originally proposed a rule to see if we could kind of get some catch-all language about classifying offenses and marrying them up with their most similar statutory offense. But it was pointed out that that's not as clear-cut as it sometimes may seem. And the example that was provided was a few years ago, the commission classified the common law offense of affray. Mm-hmm. And there was quite considerable debate about whether its statutory, most similar statutory offense was assault or public disturb, reckless endangerment, or public nuisance offense. So and there was considerable debate and disagreement, frankly. So ultimately, the commission did adopt a seriousness category for that offense that was closer to reckless endangerment than to an assault offense.
Okay, thank you.
Any other questions?
It means if we think we're running out of work, eventually we might get around to something.
I don't think we're there yet, but yes.
Well, I don't want to I'm not trying to put more work, but there is a task force that was created last year by the legislature to study crime penalties, of which I am a member of. And that the work on that has kind of been postponed because of COVID. And that did come up in one of the meetings about some of these common law offenses and whether they should be classified. There was definitely no, I'm not saying it was leaning one way or another, but that is something that did come up. I know there's some interest among some of the committee members about looking at that.
Any further comment before I ask if there's a motion? Okay, so is there a motion to approve what's been recommended by the subcommittee at this point?
So moved.
Thank you, Senator. Is there a second? Oh, Dr. Johnson, thank you very much. So again, any opposed to the recommendation as stated, please signify by saying nay. Hearing none, the measure passes.
All right, thank you. Moving on to agenda item 6C, the last classification of the night. This is the proposed classification for previously unclassified offenses. And I refer you to the memorandum labeled proposed classification of previously unclassified offenses. For those who are new to the commission, this is not unusual. From time to time, the commission staff may identify offenses that have been charged in the courts but have not been classified by us, the commission. And so we may identify them and ask the commission to classify them according to the same criteria that we use for classifying new or amended offenses. But we were recently contacted by petitioners regarding the two offenses that are noted in the memorandum. Both carry a maximum penalty greater than 1 year, so we asked for their classification. The first offense listed on page 1 is a second or subsequent violation of obtaining, altering, or preventing unauthorized access to a wire or electronic communication while it is in electronic storage in an electronic communication system. The offense is a misdemeanor punishable by up to 2 years of incarceration and a $250,000 fine. Based on the comparables provided on page 2, the subcommittee recommends classifying the offense as a seriousness category 6 property offense. I will note that for a first violation, the maximum penalty is 1 year. And the first violation is also not listed in the guidelines offense table, but by guidelines rule, since the maximum penalty is 1 year or less, the offense will be automatically categorized as a 7. But for clarity purposes, the guidelines subcommittee recommends adding the first violation to the offense table when the second or subsequent violation is added. And so we will plan to do that, assuming the subcommittee adopts a recommendation to classify this offense. So that is the recommendation to classify it as a category 6 property offense.
Any question or comment before I ask for a motion? All right, is there a motion to approve?
So moved.
Okay, I see Senator Kelly and Mr. Fincy. I saw your hand up also. We can get you two both in there. Is there any further discussion then? Seeing none, all those opposed to the recommendation, please signify by saying nay. None opposed, measure passes.
Okay, the second offense listed on page 3 of the memorandum is embezzling or altering a will or record, for short. The offense is a misdemeanor. It's punishable by up to 7 years of incarceration with a suspendable minimum of 3 years. Based on the comparables on page 4 of the memorandum, the subcommittee recommends classifying the offense as a category 6 property offense. I will note that the most substantively similar comparable offense is listed first on page 4. It is destroying a will, and that is punishable by up to 15 years with a suspendable minimum of 18 months. Given the seriousness category classification of 5 for that comparable, the subcommittee agreed that it is appropriate to recommend a category 6 for the offense here at question, which is again is embezzling or altering a will. So I will recommend that as, or I will note that as the recommendation of the subcommittee.
Okay, any questions about that? All right, is there a motion to approve? Let's see.
So moved.
Thank you, Senator. Is there a second?
Second.
Dr. Johnson, were you raising your hand? Very good. Thank you very much. Any further discussion? All right, any in opposition to that proposal, please signify by saying nay. None opposed, measure passes.
Okay, thank you. I'll move on to the last item on the agenda for the Guidelines Subcommittee report, and that is the review of the American Bar Association, or ABA pleas as we refer to them. So this topic originated initially due to the frequency of questions the staff receives asking for clarification on what constitutes an ABA plea. The staff communicated with Judge Wilson that we received multiple questions about this topic, and accordingly, the topic was designated for review by the Guidelines Subcommittee. In the Sentencing Commission's 2019 annual report, which was published in January of this year, the Commission indicated its plan to review the definition of binding ABA pleas with the understanding that the review would necessitate a fuller discussion of guidelines compliance and the longstanding ABA plea agreement compliance rule. For the purpose of review, and for those that are new to the Commission, the ABA compliance rule indicates that sentences that are adjudicated pursuant to an ABA plea agreement are deemed guidelines compliant, regardless of whether the initial sentence, which is defined as the sum of incarceration, credited time, and home detention, falls within the applicable guidelines range. The Sentencing Commission adopted the ABA plea agreement compliance policy in 2001 to acknowledge that ABA pleas reflect the consensus of the local view of an appropriate sentence within each specific community. The rule was adopted after the Commission received feedback from the judiciary indicating that sentences should be deemed compliant or consistent with the guidelines recommendation when both the state and the defense agree that a particular sentence, typically a below guideline sentence, is the most appropriate sentence given the particular circumstances of that specified case. During the most recent legislative session that completed in, I guess it ended early in March, House Bill 1458, known as the Truth in Plea Deals Act of 2020, was introduced. House Bill 1458 provides that a sentence imposed pursuant to a plea agreement may not be deemed compliant with the sentencing guidelines unless the sentence falls within the actual guidelines range. As you may recall, in March of 2020, the Commission voted to oppose House Bill 1458. This Commission submitted written testimony explaining the Commission's vote to oppose the legislation. The testimony noted that the Commission already provides or already indicated its plan to review the 2020, the current definition of a binding ABA plea, with the understanding that the review would necessitate a fuller discussion of guidelines compliance and the longstanding ABA agreement rule. The testimony further noted that the Commission appreciates the legislature's concerns and asked the legislature to defer to the Commission to systematically study the issue and report its findings to the legislature by the start of the 2021 General Assembly session. House Bill 1458 did not advance out of the Judiciary Committee. But as promised in the Commission statement, in response to House Bill 1458, the staff presented this issue for review to the Guidelines Subcommittee. And can everyone hear me?
Yeah.
Okay. Sorry, I thought it may have froze up there for a second. Okay. The staff presented two questions for consideration. First, should the Commission clarify the definition of an ABA plea agreement and or provide specific examples of what constitutes an ABA plea? A Maryland Rule 4-243 defines a binding plea in Maryland. Staff have engaged in conversations with judges and other criminal justice practitioners that suggest there is a difference in opinion regarding what constitutes an agreement proposing a particular sentence, disposition, or other judicial action. The second question the staff presented to the subcommittee was really a good question about the compliance rule itself. Should sentencing events resolved by an ABA plea agreement continue to be deemed guidelines compliant, even if the sentence is outside the recommended range? The subcommittee completed a thorough and robust discussion of this topic during its June 18th video conference. And we had a thorough review of what constitutes an ABA and binding plea. Ultimately, the subcommittee did end up asking the staff to do a little bit more research on the issue. Particularly, the subcommittee thought it would be helpful to research how the federal rule and also how other jurisdictions define a binding plea agreement, and suggested that the federal definition could help inform the commission's definition. So the subcommittee asked staff to research how other jurisdictions define binding pleas, and also to address all the implications for a binding plea so that we have all that information available to consider. The staff plans to research this issue and present the additional information to the subcommittee, and the subcommittee plans to revisit the matter at its next scheduled meeting. I present that as the conclusion of my report on this particular issue.
And thank you, David. Having attended that conference also chaired by Judge Avery, it was a very thorough discussion, and I think what the questions ultimately asked by the subcommittee really did identify the middle ground that we all agreed on, which is if we aren't even talking about the same things, how can we really try to discuss a policy going forward? So it was one of those, instead of talking about apples and oranges, let's just get on the same page, and then as a commission, of course, we can move forward. Judge Avery, do you have anything else you want to add?
At this stage, no. I think it's better to let the commission staff do its work, and I don't have anything to add at this time.
Okay. All right. Well, thank you, Dr. Slay, for that report. That was quite thorough.
Okay, ready for me to talk more?
Yep, you're up again.
Okay, so for agenda item, 7, I guess, is the guidelines, or excuse me, the executive director report. I do have 5 items to review. I just wanted to update the commissions on a few things that the staff has been working on or going through. The first item that I want to talk about is the criminal justice survey that we sent out. As some of you or most of you know, the commission distributed a survey to circuit court judges, prosecutors, public defense attorneys, and private criminal defense attorneys, soliciting feedback on the sentencing guidelines and the activities and work of the commission. 223 survey invitations were distributed. We received a complete response from 103 respondents, equaling a completed survey response rate of 46, just a little over 46%. According to surveymonkey.com, which is very popular, I know it's an unusual name, but it is a very popular survey website. Typical response rates range from 20 to 30% for a customer service survey. You know, given that the commission has a relationship with our targeted audience, we certainly were hoping for a higher rate, and we did receive a fairly good response rate. The rates were well distributed, as we received at least one response from each region or judicial circuit in the majority of the recipient categories, again, which would be the judge, prosecutor, and defense attorneys. So many of the questions were open-ended questions, and due to the nature of that, the staff needs a little bit more time to kind of go through those responses and really to organize them in a more easily digestible manner to share with the commission. And so we are currently working through them. It was certainly interesting to receive the response. Our plan is to prepare a report to present it in an organized manner, but probably to include an appendix that has the text. If you're interested in seeing, you know, the exact text responses that were provided, you have the ability to do that. So we should have that ready for the commission by our next meeting.
Thank you.
Okay. The second item that I want to report on is updates to the sentencing guidelines and the guidelines offense table. There are quite a few amendments to the guidelines and the offense table since we last met in person, which was in December 2019. And I just want to quickly highlight those. First, on February 1, 2020, the commission released version 12.0 of the Maryland Sentencing Guidelines Manual. The manual 12.0 revised Part A of the offender score to allow it to differ across offenses and multiple offense sentencing events. That was something that the commission had worked through and adopted back in 2019, if you recall. So that is a rule that went into effect in February. The 12.0 version, the manual also provided updated sample cases to reflect those revisions to the offender score. and other minor edits and formatting changes. An updated version of MAGS, the Maryland Automated Guidelines System, which version 9.0, was also deployed on February 1 to coincide with the adoption date of the revision to Part A of the offender score. Next, on April 1st, 2020, the Commission revised the Sentencing Guidelines Manual again and corresponding guidelines offense table. This was version 12.1. It was amended to add new offenses that were passed during the 2019 legislative session. There was a new offense that we had missed on our first go around in classifying offenses. That was committing a crime of violence against another person when the person knows or believes that the other person is pregnant. So we had missed that on our initial review, and that got added to the offense table in April. Finally, on July 1, the Commission released version 12.2 of the manual and corresponding updates to the list of offenses. The Guidelines Manual 12.2 clarifies the instructions for scoring the prior adult criminal record component of the offender score to indicate that certain military adjudications shall not be included. For those of you who may recall, that was an issue that we debated again in 2019 and revised the rules regarding the prior record to exclude military adjudications in most instances. 12.2 also classified conspiracy to commit a lawful act by unlawful means by indicating that the seriousness category shall be the same as the most serious unlawful means by which the lawful act was to be accomplished. And next, MAGS was updated to add a unique entry for CDS distribution, possession with intent to distribute, manufacturing, et cetera, fentanyl to the list of offenses. That was a one that was not specifically uniquely classified before, and we would get questions specifically about fentanyl and what category it should be included on. So we added a unique entry for it into MAGS to make that clear. And then finally, a few offenses with maximum penalties of 1 year or less were added to the offense table. That's something that we will do from time to time. We will add offenses when it's something that we get questions about. So where practitioners are asking us, hey, where's this offense table? We don't have every single offense of less than 1 year in there, but if they're asked about frequently, we will add them in so that they can be included in the guidelines calculations. Okay, the third item I want to update the Commission on is the guidelines webinar that we have been planning. As you may know, the Commission had planned for our first time to conduct a guidelines webinar training on April 17th, 2020. In the past, we've always done in-person guidelines trainings. We do have web-based videos for MAGS, specific to MAGS, but even prior to COVID, we kind of came to the rationalization that we needed to be able to provide a training in a webinar-based formats because it wasn't realistic for us to go out in person every time someone requested a training or was in need of training. So we had developed a plan to do a webinar, and it was going to be on April 17th, and then COVID interrupted, and we weren't able to access the necessary equipment in order to conduct that webinar, so we had to postpone it. However, we are currently making arrangements to get moving again on that and to complete the webinar from our office here in College Park. And we expect to announce a date for that webinar very shortly. We're looking at probably the first or second week in August. So we'll be sending back out an invitation. We had 70 something people that signed up the first time around, which was really robust. We were glad to see that. So we hope to have people that are still interested again at this time. The fourth item on the executive director report that I want to talk about was something that we're calling the sentencing snapshot. In our 2019 annual report, we indicated our intention to produce a series of topical mini reports to highlight statistics on topics of interest. The staff entitled these sentencing snapshots, and we hope to provide a closer look at figures that aren't captured in our annual report. And we want to do so in a shorter, more easy to digest format. As you know, one of the goals of the Commission is to aid in the understanding the public's understanding of sentencing policies and practices. And when asked about the sentencing guidelines and the effectiveness of promoting fair and proportional sentences during the survey, which I referred to earlier, more than a few respondents indicated that they would like to see the commission's data and reports to be more easily available and widely accessible. So given this feedback, we think that the snapshots will be well received, we hope, by the criminal justice community. And we plan to publish the snapshots on a quarterly basis beginning this summer. They will be sent to all recipients on our listserv, which includes judges and administrative assistants and law clerks, prosecutors, public and private defense attorneys, and correctional officials, and anyone who's previously expressed interest in anything guidelines related. The snapshot will also be posted on our website for access to the public.
Excuse me, it occurred
Sure, go ahead.
that the legislative committees that do this work might be also interested in getting that.
I will be happy to reach out to them, Senator Kelly, and ask if they are interested. So we can do that, and I think that's a good idea.
Mm-hmm.
So our first series of snapshots, we plan to provide a closer look at the average sentences for different categories of crime. For instance, the first snapshot will focus on crimes of violence and firearm offenses. That's something that we've received interest in the past. And then we'll move on to looking at other person offenses, drug offenses, and property offenses, and really just presenting the data in a manner different than anyone is accustomed seeing it before in any of our reports. And we hope that they will be something that are of particular interest. We are open to suggestions to future topics or statistics that you would like to see covered in these snapshots. So as commissioners, you'll receive them. You'll be on the email distribution list, so that'll be a reminder. But if in the meantime, if you think of something that you're particularly interested in, please feel free to reach out to myself. And that's something that we can plan to see if we can address.
Uh-oh.
Uh-oh. Yeah.
Do you think he
Apparently,
burned out?
David is
Getting to the good
unfamiliar
stuff.
with the time limitation.
Do you think he burned out his internet connection talking too much?
I think that might have something to do with it.
Yeah.
All right.
It shouldn't end the call.
We may also
Here
be
he
getting a little
comes.
interference, storms in
There's
the
a
area.
thunderstorm. There's a thunderstorm in College Park right now, so whatever.
Okay.
So
Well, he was just getting close to the budget, and we don't really want to hear about the budget anyway, so that's the painful part.
yeah, it looks like
All right, he'll
Catherine
come back
has.
in a second.
It looks like
Divine
Catherine has
intervention.
lost too.
Yeah,
I'm here. He should
Oh,
hope
you're there now?
back in. Yeah.
there he is.
All right. Hi, everyone. I'm back. So I don't know if it's storming here in College Park. I don't know if that's impacting me some way, but I'm almost done. So hopefully we'll be able to wrap up here. I apologize for that. The last item I wanted to report on was the budget and the impact of COVID-19. As everyone knows, due to the COVID-19 pandemic, the commission and all state agencies obviously are impacted on this from a budget perspective. And we were required to submit a budget reduction proposal for fiscal year 2021. Preferably we would have had the opportunity to reduce operating costs, but just to be frank, the commission's operating costs are so low already that we didn't have any area there to really reduce. Consequently, we had to make a difficult decision to suspend the graduate research assistant position for fiscal year 2021. That was really the only area that I possibly had to cut from. The policy analysts understand.
A question. Would it be appropriate if some of us on the commission wanted to make a contribution for enough just to have a nice stipend for a graduate?
I'm not sure how to respond to that. It's very generous, Senator.
Well, let's put it on an agenda for next time. I'm throwing it out as an idea. I'd be willing to contribute, if between us all, we could raise $800 or $1,000 or something for some kind of a stipend.
It's the stipend, it's because it provides a stipend and graduate tuition remission for graduate school. So it does come.
You University of Maryland. No, I'm an alumna. We'll talk to the new president.
Well, I could appreciate anything because listen, I mean, one of the points I was going to make is, the policy analyst position, many of you worked with our policy analysts over the year, and we had a really good one this last year. And I'm sorry to see him go because he was planning to come back. He was a doctoral student in the criminology department. And we really do rely on the policy analysts to do a lot of it. We have them only during the academic year, typically for 20 hours per week, but we certainly are going to miss having that person with us. So,
if Mr. Chair, Judge, it's okay, I would just move that we allow Dr. Soule to reach out to see if the student could get the accommodation from the university. And if so, if between us, we could raise at least $1,000 or $1,500 for a graduate student to continue with a stipend. And we could, decide based on what you tell us when we meet next.
Well, it's a good deal more than that, Senator Kelly. It's closer to like $35,000 between all the costs.
Okay. Well, how much of it does the university bear?
Oops.
The university has helped us out in the past. There's been years where the university's picked up half the tab, for instance, when I made that plea to them, but also had to cut, has substantial budget cost history. So it wasn't. Good thing was for this particular graduate student, Sean.
Yeah, there he goes again. Senator, I think it would certainly be appropriate for Dr. Slade to be able to reach out and see if there is some other accommodation you can make.
Okay.
I don't think we need to have commission approval for him to do that.
Absolutely.
Because budgeting is part of the director's job, so we can certainly advise him that, there he is, Dr. Slade. In your absence, we were just saying that it's certainly within your purview if you wish to reach out and see if there is another money tree out there.
Okay. No, I appreciate that.
Feel free to do that. You don't need our specific approval, though we certainly support you in your efforts.
Okay. Well, that concludes my report, executive director report. And I appreciate that. Thank you so much.
Sure. All right, well, that moves us on just to reminders about the remaining meetings for this year. We have a September 15th meeting at 5:30 p.m. And right now it is scheduled to be in person. Obviously, we'll see where we are as we get closer to that date. And that would be at the new Maryland Judicial Center, which is down just outside the city of Annapolis. And what's the name of the street it's on again? I can't remember.
Riva Road?
No, it's off Riva.
I should know that, but
president or a general? I can't remember.
I should know that, and I forgot. I think it's
Harry Truman.
That's it. Thank you,
Truman
Judge
Parkway.
Lewis.
President Truman. Thank you, Judge.
I'm gonna just say that I think it's highly unlikely that we will be able to meet there in person, but we'll hold out and make a decision as we get a little bit closer. But I suspect we'll be meeting via video conference again.
And of course, the next and last for the year would be the December 8th, 2025 p.m. meeting at the House of Delegates building in the Judiciary Committee chambers. If Delegate Clippinger lets us use it again, we would be very appreciative. And that would be hopefully in person so we can hear from people. Yes, there's Delegate Clippinger, the chairman.
I guess that's all right. Don't take anything.
Thank you, Mr. Chairman. With that, is there any and obviously one thing that we'll be looking into is as recommended by Judge Avery, whether to hold a special meeting on the item for discussion or to incorporate that in one of those meetings in person, but certainly to move forward on that as well. Is there any additional old business that we need to discuss at this time?
This isn't old. I don't know if this counts as old business since we talked about it earlier tonight.
Yes,
but it struck me as an idea that I wanted to throw out there while I was thinking about it, which is the idea of these mini reports. What did you call them, David?
Sentencing snapshot.
Yeah, sentencing snapshots. I wonder if the commission does eventually support a new analysis of racial disparity, that would be an interesting topic that maybe could be summarized in one of those kinds of reports and distributed widely, to the interested parties. So it's a topic that might be suitable for that down the road at some point.
Yeah, that's something that I think is a good question. That we would have to, it probably could be covered in brief in some sport. We really wanted the snapshots to be just that, a snapshot, a brief. Sometimes the race analysis is something that could be somewhat complex to probably capture in a brief type of analysis like that. So that was something that the staff had debated. So I think that's something that we can explore further.
But maybe on that one, at the least, you might be able to get us a bibliography and some other materials on the issue.
That's true. That's a good point.
Anything else for old business? All right, is there any new business and announcements other than the upcoming meetings? Anything else? All right, seeing them, well, listen, I really appreciate everyone who's attended tonight. Obviously, as you know, there was a lot of business to conduct that needed to be done to help the staff and Dr. Slate continue with their good work. As the item 4 discussion about the national conversation on race and criminal justice and within the state, I just say that obviously we all have personal and professional roles and responsibilities in addressing the needs of the community. This is a wonderful opportunity for us to try and contribute, both by shedding light on the past and also hopefully shedding light to go forward in a positive direction. So I look forward to that discussion. I know we all do. And thank you all very much. Be safe and take care of yourselves between now and the next time we meet.
Thank you.
Thank you.
Thank you.
Thank
Good night,
you.
all.
Thank you all. Good evening.
Okay.